Well, thank you everyone for sticking around until this late hour. I think this panel is like the most challenging for two reasons. One is that it's a panel to find the solutions to the problem. And the second is that we have to keep the audience awake. And we'll try our best to do it. My name is Francesca Micheletti. I'm a reporter for Politico here in Brussels, and I cover competition policy. Here let my speakers introduce themselves without too much of an introduction. I welcome this panel of speakers who are, I think, the most acute observers of competition policy and its dynamics, and today they will help us go through solutions to the issues that we've highlighted in the previous panel. Each of the speakers will give a short introduction on their key thoughts on what the solutions might be, and then we will open up for an interactive discussion, and at the end, hopefully some time for Q&A with the audience as well. So I will hand it over to Thomas. Actually, no, Tommaso, sorry. The order, Tommaso, you are the first one. Yes. Can you please, no need for introduction, but just introduce how your daily experience relates to the topic.
My daily experience, I'm out of this, so it's great.
Where do you get your coffee in the morning?
Okay. The coffee, the important thing is, so we're going to talk about solutions. And solutions, there are quite a few which have already been flagged. I think that some solutions are almost obvious and they're easy to implement. Some others are much more difficult. So awareness, informing people of this issue, part of this event is great for that. That's good. But instead, working on the incentives, which are so asymmetric given the money at stake, this is much more difficult to do something about, and so some regulations may be needed there. So I'll start to divide something which relates to academics vis-a-vis something that relates instead more to the professions. Among academic, we have a wrong structure when it comes to issues related to policy, a wrong structure in publishing incentives. Most academics are not interested in policy, they do other things, etc. We don't even have somebody representing academia as such in this debate. So if you ask a room of good IO economists, do you think that on average mergers are bad? So mergers in concentrated industries, are they bad for prices? Everybody would say yes, but then you put the same people in front of a case and say, well, it depends, there are efficiencies on the cost side. So you never have this received wisdom because academia is not organized. It's not somebody who's representing the average view. You don't need to be 100% sure, otherwise it would be cast in stone. But if you are 80% sure that something is bad, that's good enough for policy, in my opinion. So there we have to rethink sometimes the editorial processes. More enlightened editors should be open to policy papers, even if they're a little bit less precise, but they're interesting in terms of the ideas, and we have to promote that. And this has to be done by the more senior people, because the junior people are instead up for tenure. They have other priorities in their mind, and they cannot do that. So the publishing incentives are wrong. We can do something, some initiatives to make it better, special issues of high reputable journals, etc. Something that we touched upon earlier also, which is very, very important in economics, on the academic side, more and more of our published work comes from empirical works, but you have very biased research. So even if the work in itself is a clean one, if Uber, this is what Luigi has identified as the Uber problem. Every time you see a paper about Uber, you already know that whatever the researcher finds is favorable for Uber, even without reading it. So you're not going to get to the core of some research question unless if you have, unbiased data with no strings attached from some companies which are not going to release voluntarily those data. So we could do in other concentrated industries research in the past. I think of telecoms, I think of pharmaceutical, I think of airlines, because regulators oblige those companies which have special requirements to share data with the regulator, etc. And we have to do, when it comes to big tech specifically, we have to do something similar, because you cannot wait until they voluntarily share something, because this will have plenty of strings attached, and I can give you some cases if you're interested. A problem of revolving doors is very difficult to resolve. We discussed a bit earlier. We can do something. Maybe it's wishful thinking, but something that might help is thinking about agency compensation, because sometimes people go on the other side for monetary incentives. But then, post-employment restrictions, the length of the cooling period, and monitoring. This is, especially as we said earlier in an earlier discussion, especially for those at the top, is something that we have to do. The problems that we currently have when it comes to solution is that anytime somebody doesn't follow these rules, there is no actual punishment. So we can expose it, but there is no actual punishment, which is something we have to think. I don't want to be polemic, but simply because in the previous session there were 3 members of the CAT. I will finish with an anecdote, and then I have some more things to say later on. But I did. Since I left the commission, I work only on 2 cases in which I was I was representing the CMA in front of a CAT on some excessive pricing cases. So I accepted because I thought they were interesting, and there were cases where I thought I hope a good economist could be helpful to the enforcer. So I did those. They were run very differently. One, there was a hot tub, which was interesting to expose differences among the experts. The other one instead was run in a totally different way. And there was a point in time, and I just wanted to think of what sometimes institutions do. And the question would be, why do they do that? So I was there. My duty was to help the tribunal. But then there was a litigator that was this is cross-examination. It's a tough deal, fine by me. They wanted to push me in the corner. At some stage I said, Professor Valletti, what do you think of the consultants on this case? And I said, I looked at the guy who was presiding the tribunal, and I said, I think this is totally irrelevant. I'm here to help the tribunal on this case. I want to stick to economics of the case. Then the president of the tribunal forces me to answer. You really have to answer. Okay, since my duty is the tribunal said, okay, you are getting us into a street fight. I think we shouldn't do that. Anyway, you really want me to tell you what I think, my honest view. You're asking me to, and then there were 3 consultants said, Mr. A, different views, but it was professional. Mr. B, different views, but it was professional interaction. Mr. C, and I gave reasons. I thought that this guy did very bad economics. Very bad economics, and I exposed it in my reports. It was a very bad interaction, and that's what I said. And then the president of the tribunal says, this is unacceptable. You have to apologize. And since I'm a hot-blooded Italian, I say, excuse me, first you ask me to answer a question. I think it's inappropriate to answer the question. Then you force me to answer the question, and then you don't like my answer? That's really bizarre the way you are conducting all of this. Okay, end of the story. But then there is the judgment. Okay? Remember, I decided also to do these cases because I thought it was my public duty sometimes to expose the bad economics, because to be credible, there has to be good economics. Now, in the judgment of the CAT, there is nothing about the quality of the expert witnesses, the others. They only profile me, okay? And they say, Professor Valletti, yeah, good economist, but very outspoken, okay? Very naive, which I'm not actually, but very naive. I had a report, and they said, he said, quote unquote, that consultants are guns for hire. Okay? Footnote, he didn't actually say that, but that's what he meant. He said, sorry for the jargon, but what is that? I mean, this is in a judgment of the CAT. So when I met this guy months later, because sometimes there are some social events, we had a couple of glasses of wine, etc. And then I asked him, why on earth did you write that instead of exposing the bad economics? Instead, you profile me. But by the way, this is a stain on my CV, which means I'm never going to go in front of the CAT ever again. So I said, why did you profile me? Because I'm interested to know. And he said, which was interesting, he said, the system depends on the credibility of the economic witnesses. If you discredit the credibility of the economic witnesses, the whole system falls apart. So there's a lot of collusion in this very cozy world that we need to, unfortunately, to expose as well. So remember, I was the one singled out, not them. I'll stop here.
Thank you, Tommaso. We now turn to the European Commission view, of course, personal view of Thomas Deitenhofer, who is, however, a long-standing EC official who has history in some of the big cases. Can we say the Bayer Monsanto case was a highlight, and he will give us his perspective, solutions-oriented perspective.
Thank you, Francesca. Thank you, Johannes, for inviting me. Indeed, my background, what brings me in contact with conflict of interest, is a bit twofold. One is I was a merger head of unit and dealt with quite a large number of cases where we had academic studies, consultant thrown at us, or I had these hearings with Patrick Rey on the other side and in GE or in Dow DuPont and other cases. And the second job is my current job. I'm a principal advisor for ex post economic evaluation. And in this job, I'm recruiting, tendering studies, recruiting teams to do external studies, economic studies for the Commission, which are an important input for our policy. Now I have to say upfront that I will speak only in my personal capacity. I will listen in the Commission's capacity, so I'm a bit split person today because I'm interested about what's going on. Now, solutions-oriented. Francesca insisted 3 times that I should be solution-oriented. I want to make three points. And the first one is I believe that this problem is really a big problem and a systemic problem. And it's a collective problem affecting various parts of the whole competition ecosystem community, and can therefore also only be solved if it's a collective effort by this whole ecosystem of competition community. I was very pleased with and grateful for the speech of Jonathan Kanter, which I'm surprised nobody quoted today, and there were some really, I think, very important ideas in his speech there. And I mean, competition, this was said today, competition is a bit like tobacco. Competition is highly complex. So it's complex because the competition law, the economics are complex, but then you add the complexity of the sectors. So double complexity. And then it's highly asymmetric. The interests on the one side are concentrated. The information is not accessible to the other side. There's a huge veil between one side who has all the information and, let's say, the harmed side, the smaller businesses, consumers who have no information, no access to that information. And then the capacity to organize these industries is obviously also completely asymmetric. We are in a similar field as in consumer protection, where you have this asymmetry. Now, Jonathan Kanter made 3 points with which I agree, that the problem is not really that there is advocacy and that there is expertise. The problem is that there is no proper separation between the two. So we can have advocacy, we need expertise as competition community, but what is the problem is the expertise which comes, or the advocacy which comes, which is presented to us as expertise. And this blurring of the line is really what we need to get at. We need both. We need expertise, we need advocacy, but they need to be strictly separated. Now, why do I say we can only do this collectively? Because it affects, first of all, academia. And academia, as was said today, is really complicated. Again, sorry for using Toulouse as an example, but if Jean Tirol's Toulouse School of Economics get some corporate money, and they need to have some corporate money because there's not enough public money for research in France, probably, so it's a good idea to get some money. But it may well be that it's Airbus. It's in Toulouse, it's next door. So what about doing a study on coordinated effects in duopolies in the aircraft manufacturing market? You will not do it, probably, or it's a difficult topic. Even with the best intentions, with honorable people, it's complicated. And on the other hand, without the money, it's not possible. So the first front line is academia, and the solutions are not simple. I like the idea of pointing to medicine. The conflicts are there, they exist for many years. This has been dealt with. They're pervasive. My sister is a cardiologist who does research with medical device manufacturers. It's all the time. They have to deal with this and tackle this. Second, the journals, economic legal journals, obviously there has to be improvements. The disclosures are not clear. Today we heard about the data, which can also be a problem. There's a lot of room for improvement, but I would add, it's not just disclosure, it's also balance. And I think this is something which has not been talked about today enough. One fundamental assumption I always have is that everybody is biased. So the important thing is that you bring the people with different biases in the same room or in the same journal or in the same conference to get balanced views on the same courtroom. Ordinary newspapers, we heard it today, very often they are victim of a piece which looks neutral but which is actually a hit piece or a paid piece. And I think there needs to be a lot of improvement. Also there, is this the minimum? They should ask who's financing, who is the non, and the disclosure should be there. Conference organizers. We have spoken about disclosures. I think what's a wonderful initiative is what has been done by the FTC, Bureau of Economics, have issued really good rules for their own conferences in the hope that these rules are copied by private conference organizers. And I'm hopeful for some academic conferences, but my question, what about these paid conferences? Why would a paid conference where speaker pay to speak have an incentive to force that speaker to disclose the money where the financing? Perhaps that speaker will then not pay or not that much. So I mean, the economic incentives in this whole circuit are against disclosure and would need to be checked. Last point, I've had, and this is a question on sanctions and ethics. Lawyers have, as we all know, doubtful ethics. I'm a lawyer, so like everybody accepts that. But possibly doubtful ethics, some of them. But there is a bar rules, and there are ethics rules, and you can be disbarred. And in my practice as a merger enforcer, I had the real case of a lawyer presenting me, we need to carve out a beautiful production line of this remedy to keep it. And here is the economist who gives you the numbers on the capacity. And the numbers of the economist said it's 10,000. And then we found out that it was actually a mistake by a zero, and it was 100,000, and that made all the difference. And the whole thing was set up in a way, the lawyer knew perfectly well that if the lawyer comes with this number, there is personal liability. Risk of being disbarred. And everybody knew that there is no risk of personal liability if you are the IO economist. And so I think, this profession is now $1 billion profession. It's like chartered accountants. It's like I think it's time to think a little bit personally about ethics rules which match those of the lawyers' personal liability. Now, I'm talking, it's easy to talk about solutions for the others. What about solutions for the Commission? That's a bit more delicate always. But it's fair that I have to speak about the Commission. The first thing is here, I have to caution, and I think it's the same as I said for the universities, also what Filippo said this morning. Don't think that it's so easy to find always solution. It is often very complicated. And I give you just, we know that there is this inherent conflicts all over the place. So the first thing we do, that was Anna Sophia also said this, we try to do as much as possible in-house. That is for us the best guarantee to have no conflicts. So the hardcore of our work, investigation, questionnaires, nothing of this is outsourced. Economic analysis, heroic 20 CET economists facing huge teams, but they still try to do it in-house, not to have to take experts. We are different. In the US, bigger teams, FTC, DOJ, but more outsourcing for the economic expertise. We don't. We are just two economists against the rest. It's really, we go so far also because we are scared of any bringing external expertise into the core of our cases. So what remains where we have external expertise is kind of the sideshow. The sideshow is monitoring trustee, studies, and industry experts, where we really cannot have them in-house, and we have to have them. And for those, I would say there are three challenges. One is if you want somebody who has industry expertise, how can you get somebody who has not been in the industry? Same on expertise on mergers. Second inherent problem, we don't have much money. So the stuff we were going to pay is peanuts compared to what's at stake. Third problem, the academics that we would like to have, they don't have even the time or the resources to tender. We need to do a public tender. The academics cannot participate directly, they don't have the time. So we need to go through private commercial suppliers, otherwise we don't get this expertise. So we need to go through a consultancy, otherwise there's no way to even get to the academic. We can then get to the academic, but we need to go through things. So it's not so easy. To conclude now with two examples, it's what do we do with monitoring trustees and what do we do with studies. Both delicate and both difficult. Monitoring trustees is super difficult because you are at the remedy stage asking the merging parties to contract a monitoring trustee. So the contract is between the merging parties and the monitoring trustee, and they pay for the monitoring trustee and the monitoring trustee should act in the interest of the commission, eyes and ears of the commission. So imagine that wonderful triangle and problem of interest. So how do you tackle that? There are tons of rules. We just updated. We came out with a new templates on monitoring trustee, and we strengthened them, and we brought in another layer of information obligations, even about conflicts which arise during the contract. Now, what's important is not that, actually. What's the most important is the long-term incentives of these trustees to be at our service and not at the company's service. And that is decided at the choice moment, at the selection moment. If you let the firm select the monitoring trustee, all the monitoring trustee will do the pitch to the firms and say, I'm good at hiding stuff from the commission and helping you. But we have a selection procedure now where they have to propose 3 monitoring trustees, and we have also a clause in the implementing regulation that in the end it's the commission who decides in case of this fight. Yeah, does it mean that the monitoring trustees know that they have to be trusted by us if they want to have long-term business? And so these completely changes the incentives. Tommaso mentioned incentives as the key point in the whole selection of the monitoring trustee and guarantees that we have good monitoring trustee in most of the cases. Second problem, studies. So big problem, because lots of, as we know, we have the asymmetry, lots of corporate interest in getting certain results from studies, also from the consultant side, interest to get certain results from studies. On the other hand, we cannot have anybody else than consultants working, replying to tenders. We won't get responses to tenders. No, we had always conflict of interest rules, but it was a box-ticking exercise, and it only focused on the conflict of interest, whether there was prior involvement. And in the meantime, there had been a case called the BlackRock case and the Ombudsman in Europe, which said, listen, but there are also these studies where there was no prior involvement, but where the economic incentives of the firm are such that this firm is unlikely to make a really neutral assessment. And so we had a case where we had selected a firm who was not personally involved in a selection, but it was then involved in a management, which was a problematic selection and which caused problems because the firm clearly perhaps had flagged the involvement in prior cases. You can deal with this with Chinese walls. But the bigger problem was that this firm was a constant advocate in front of the commission. And that fundamental conflict of interest that it could not, at the one hand, support a finding of a study, which then, in the other hand, would fire back in its consulting work, made that a firm not a good candidate for such a study. So this study was then terminated after quite some upheaval. In the meantime, we have strengthened our rules on this for conflict of interest, and we are struggling to get lots of safeguards into this process to cover these two types of conflict of interest. And my best attempt, but it's a best attempt, is try to get a consultancy that which has not a lot of business with the commission. Try to make sure that the study is supervised with a reputed independent academic. So the consultant hires the reputed academic, but the study is signed by the academic in blood by his or her name. Make sure that there is possibly a second pair of eyes review process, which is not controlled by the consultancy, but is controlled by ourselves. But also be very clear that if the conflict is too fundamental, you have to simply say no, and there is simply no study.
Thank you, Thomas. Well, it looks like you're well ahead in already implementing the solutions. So I thought we would just be discussing proposals, but it seems that at the commission level you're already going forward with these two items you've mentioned on monitoring trustees and...
Perhaps these are all implemented and all realized and have, for example, in the study, so the monitoring trustee, the papers have come out last week, the new papers, but the old ones were already good. On studies, we have implemented this since 3 years, right after the problem with the other study. And so the study that has not just come out now on remedies, antitrust remedies, was already tendered out under the new rules and was controlled under new rules. And we are quite happy with the result. What's important, I said something, it's a collective effort, but it's not just a collective effort. It's a permanent effort where you have to constantly adjust and learn from and improve from past mistakes. And every tender, we try to do it a bit better than in the last time.
Yes, and as you say, it's a collective effort. I'm happy to give the floor to other members of the community. So we have Vanessa Turner from BEUC, who will mention her plans.
Right, good afternoon, everyone. I hope you can hear me all right. So I'm going to practice what I'm about to preach first. So just for anyone who doesn't know who BEUC is, we are the European Consumer Organization. We represent 44 independent consumer organizations from 31 European countries. We are funded by our members by a grant from the EU and by independent foundations. I wasn't going to mention this, but I think it is actually relevant. Before becoming a consumer advocate, I have actually revolved a few times. I started off as a private practice lawyer, partner in 2 law firms here in Brussels. I then moved into the Commission. I was then general counsel of Visa, much mentioned company already today. Yes, and I did do the antitrust work for many, many years. And now I'm a consumer advocate. So I want to put all that together and for the solutions that or my ideas for some solutions that we're going to discuss. But before I start looking at some possible solutions to these conflicts of interest, I really would like to stress that I think academic input in competition policy is essential. And to quote Cyril Ritter, who's written an excellent piece on this issue, almost every idea deserves to be discussed, regardless of its motives or sponsors, and whichever side you're on. But for me, an unprincipled approach to such inputs leads to bad outcomes. So we need to solve the bias introduced by money. I'm going to leave data on one side for the moment, not by opinions. So if I then take the title of our panel, there were 3 options that we were looking at. So for me, the market option, which is suggested, has not fixed the bad outcomes, nor do I think it can fix the bad outcomes. I mean, in theory, expert academics are repeat players, so market mechanisms should induce them to guard their reputation and professional honesty and integrity. And these credentials, perhaps more than winning the case, should generate future work. But I think, and I apologize, much of IO economics, in some cases, theory is inconveniently disproven by reality. So, having rejected the market solution in this case, for me, the ideal solution probably to prevent academic capture would be regulation. Payment for an opinion cannot but distort the opinion. We all know there's no such thing as a free lunch. A paid lunch, yes. But I think in today's simplification world, regulation is as unlikely to materialize as market forces fixing the problem, though I'd be happy if the two legislators on our panel were to tell me that I'm wrong on this. That would be delightful. Shame.
But it's your mistake. You are voters. You voted for this majority.
I didn't. Anyway, so that leaves us then with the third option, which is self-regulation. And I think this, in the broader sense, could at least deliver some answers if some people are willing to give it a go. So I'm going to divide my ideas into two groups. First of all, ensuring transparency. It's been a bit of a theme, and I'm going to pick up on some of the issues that were discussed by the first panel of the conference. And then I have a second lot of ideas which are more radical, which we'll probably come back to. So on transparency, I'm going to look at three areas: publications, already discussed a little bit, conferences and consultations, and academic institutions. So starting with publications, and this has been mentioned, many publications have transparency or disclosure rules, but not all of them do. And in my view, not all of them go far enough to be effective. So I think publications could self-regulate to require effective disclosures before they agree to publish an article. And for me, those effective disclosures should cover, I mean, there may be others, and this actually I should take is from a publication on which I'm an editor. These disclosure rules, in my view, should involve disclosing involvement in legal proceedings or advice, currently and previously, because you're not likely to contradict a view that you've held before. Should disclose any funding received in relation to the article, whether any corporation or its advisors have reviewed the article, and any other relationships or facts that could negatively affect a reasonable reader's assessment of the scholarly independence of the article. And picking up on another theme, I think failure to comply with the rules on disclosure should be sanctioned. We've discussed what should that be. Well, one rule for me would be disbarment from the ability to publish in that publication for X years, however many that is. And in the case of recidivism, permanent disbarment. I told you I was going to be a little bit radical and provocative here, but okay. I think the problem deserves some really good solutions, really serious solutions. So turning to my second topic, conferences and consultations. Academics, but also lawyers, economic consultants, and it's sort of been mentioned, astroturfing industry associations, should be required by conference organisers as a condition to speak on panels to make proper, not meaningless, I've worked on both sides type things that we were discussing earlier, proper disclosure. Nor should they be kind of long lists. So we discussed a bit, what could you disclose? One thing that comes to my mind is that an effective disclosure would be one that says something along the lines that on X issue, the subject of the panel, I have been paid to write Y. So it gives the audience a specific reason to understand where you're coming from, not some kind of I've worked for everybody disclosure, which gets you absolutely nowhere, as we discussed before. If speakers are not willing to make proper disclosures, they should not be allowed to speak. They should not be allowed to participate. It's a simple sanction. Either you disclose or you don't. If they fail to make the disclosure on the day, then the moderator or the other panelists should call them out. So let me come to a specific type of conference, regulator-organised conferences. this what I've just said, I think, should seriously be enforced by regulators. And at the moment, it's honoured in the breach. I don't know if anyone attended the Article 102 conference or has participated in the DMA workshops. I really do not know why regulators are not enforcing this rule to make everyone say who is paying for them to say what they're saying. Some of us are there obviously saying who we act for, others are not. And I don't think that's acceptable. And I think that's something the Commission might think about changing in its rules, not only the Commission, other regulators. So, I'll then move on to my third area, academic institutions. Now, how about a rule to not give tenure to or employment to academics who do not agree to properly disclose their conflicts of interest? And that should include, for example, when an academic has taken money for a publication, that is clearly stated on their page, the page for that academic on the institution's websites. And again, if those rules are breached, there should be a meaningful sanction. So just to kind of sum up the self-regulation side of things, I wonder if it might actually get over the current self-interest if you use self-regulation, which actually led to better publications, better conferences and academic institutions. Maybe then market forces would actually play a role. So those are kind of my disclosure ideas. My more radical ideas I'll just mention briefly and maybe we'll come back to them. My first one would be contrary to what someone else said yesterday, and there's reason behind it. I wonder if regulators shouldn't publish a name and shame list of transparency rule breakers in their jurisdiction. And we'll maybe come back to that. Secondly, I think legislators should refuse to accept expert evidence from academics who've breached transparency rules. And regulators, I think, should think quite carefully about their hiring policies. Lastly, the most controversial, and I will come to a possible alternative, I think if one had regulation as an option, prohibiting universities or academic institutions from accepting major donations from corporations could lead us to much more well thought through and genuine input into the debate on competition. I'll stop there.
Thank you. More well thought through, but perhaps less, because we know that academic institutions, as we said before, kind of need the funding. So that's again another problem. But I will now give the floor to the political side of the panel, which
people at the back cannot hear very well.
Yeah, the mic doesn't work in the speaker.
why do I always get them? Is it my voice or the mic? Yeah. So we will now give the floor to lawmakers. I realize it's not a hugely balanced panel, but I was told that there was an attempt to make it more balanced. There was an invitation yes. Right. So we're good. So perhaps Rasmus, you mentioned some difficulties, for example, around the DMA legislation. Do you want to speak a bit about that, and then what your potential solutions are?
Yes. I mean, very briefly, first of all, thanks for the invitation. I think it's really a high time to discuss those topics and also to do this like in a panel like this. I'm sorry I didn't have time to hear a lot of the other panels, but I think you had some interesting discussions also before. Just very briefly, I'm an elected member to the European Parliament since 2019 for the Greens, working basically in the Budget Committee and in the Econ Committee, also having worked a little bit in ITRE and in IMCO in the past mandate. And before that, I was a member of the regional parliament in northern Germany, just telling this because I worked on research and universities in my regional parliament back in the day. So that's maybe also like important as a background for the debate we are having here today. I would start by saying that I think, I don't know if it's contradictory to what we have heard from some other representatives here, but I think even the situation is getting worse and worse. And this has a lot to do with the political dynamics we can see. And my colleague René Repasi already mentioned this in his very short intervention like some minutes ago. And this has, of course, also to do with the political atmosphere we are living in. and also with the outcome, for example, of the European elections back in June last year, meaning that we can see, and this had also been mentioned in the panel right before our panel, attacks against civil society, against independent research, corporate interest much more on the agenda. The omnibus regulation and the proposals were mentioned, but you could also take the industrial policy, where we clearly can see that the approach of getting more corporate interests on board is much higher than what we could see in the past mandate, where we also had a lot of problems and we also had like this conflict present, but we still could see that there was big influence of the big tech industry when it comes to competition questions, or the DMA or the DSA. But on the other side, there was still like strong legislation where, like, also we know that the big tech industry didn't really was happy about what the European Union legislated in the past mandate. So this means that right now we are living in a different kind of world, also when it comes to like the role of corporate interest for decision making, both in the parliament, I'm afraid also within the commission and in other institutions as well. And then additionally, we can see a lot of more pressure coming from the US, from the new administration. I mean, many of you already mentioned the FTC. There is no FTC any longer as we had known it from the past years. And we can also see that like both Elon Musk but also Mark Zuckerberg are like calling the EU, with the backing of Trump and J.D. Vance and others in the administration, of changing legislation in the interest of like, yeah, Elon Musk and Meta and others. So this means that like things are changing, and the space also for independent research when it comes to this in conflict with corporate interests on the other side, I would like to put it like that, is huge. And I actually don't see any kind of positive, I'm sorry to say that in this way, development going in another direction right now. And this is my starting point for the debate. Also having in mind that when we are discussing also other aspects of competition policy, for example, like the question on price gouging, where we could see also some developments with recent research, like, for example, the German economist Isabella Weber had done. This is not really taken up, and we don't really have the information ready in the EU to act in a direction like this, because we know that when it comes to this, like big companies have a different kind of interest than maybe policy makers have when they are discussing the consequence of inflation, for example, and also competition aspects related to this. And this is why I think also, because we should be quite solution oriented, that from a policy perspective, and I guess René will add a lot to that, also from the perspective of a member of the budget committee, it will be important also to defend public funding for research and civil society. And we could see attacks coming from the EPP and the far right. They have, with a new majority in the parliament, against civil society. And I'm quite sure that this will be the first step and not the last one, meaning that also public research, funding for public research, going in a different direction, not linked to some of the policy goals we can see dominating right now, will be much bigger than in the past mandate. And we could also see, like in the last years, that we ended with some cuts, for example, in the Horizon program, which is still, I think, quite a strong program with quite good opportunities, especially at the European level, to do also independent research. And I'm afraid of that this will be a tough fight for the next weeks and months. The Commission will present the proposal for the next multi-annual framework in the summer. Then there will be a lot of different legislations or proposals for legislations and hopefully with a strong Horizon program, but hopefully also with the possibility for researchers to act independently and not just to like limit the space and have a bigger dependency, like the perspective of like getting more corporate money into this to get more public money as well. So I really think that this is like one of the most important points, additionally to what already had been mentioned. I don't want to repeat that. Of course, transparency is important. Access to data is important. I fully share that, so I don't want to repeat everything. But I think also like this fight on the next MFF, on the budget, on possibilities, also not just like for the research programs, but also for civil society in general to also like take part in the policy discussions we are dealing with both in Brussels but also in the member states. I think this needs also to be added, will be really important. And I also think that we could also talk about or work on finding solutions that, for example, this will be funded much more also through a contribution from big corporations, like, for example, the tech companies. I mean, why are we not taxing tech companies together as the European Union in a way so that, like, with some of the revenues, we can also give money, for example, both to civil society, but also to public and to independent research. That would at least be one option, also to ensure that like funding we could end up with more funding and not end up with cuts, because we all know that like also the member states don't like to give more funding to the European level. Now they are focused on the industry. Right now they are discussing defense. That's important, but there are maybe also coming some new problems up with like the priorities they are setting now, especially looking into the defense industry. There we will see the same developments like we can see on the tech industry, because we will have some few very strong players like having a good time in the next months and years. And I don't want to be misunderstood. I really think we need to do more there. We need to invest in defense and security for sure, but we also need to deal with the consequences of this, and we need to ensure that not everything will be dependent on like corporate interests in the coming years, but we also have a strong public dimension in this, and this can be organized, for example, via the EU budget and with instruments like taxation.
Thank you for summarizing the spirit of the times. Well, of course, less money for research means potentially more corporate influence, and therefore the more acute need to regulate or to find a solution to addressing the bias. René, do you have any thoughts?
So if I say no, then we can basically quicker get. No, well, there's still Max. Huh? Exactly. Huh? So this puts me now under pressure to say no, that I have any thoughts. Yet, given that I'm not representing somebody from the Liberal Party, I cannot say no. Must have thoughts as a social democrat, obviously. But I leave it at that remark. Since also, let's say, I think one of the reasons that I'm sitting here is that I'm not only having the politician's hat, but I'm also having an academic's hat. I became an MEP in February 2022 when my predecessor, Evelyn Gebhardt, retired. And before that, I was a professor at Erasmus University Rotterdam. I still have the chair, but at a very small size, and I was in academia ever since before. And the title of my chair, which is normally incomprehensible for anybody outside of the Netherlands because they have these weirdo chairs. So my chair is called Public and Private Interests, which is linked to the very fact that my chair is financed by a Dutch public research program. And that was looking into the relationship between private actors and public interests. And when I got appointed on this chair with this particular research theme, I thought, oh my gosh, what am I going to do with this here? The old public-private interest debate, I mean, that's settled already for 100 years. I have to also disclose I'm coming from German academia, where we have a certain kind of discourse on these kind of matters. But going much deeper into this, you discover it's actually quite a hot topic. And as a starting point, let's say there is a link to our discussion today as a starting point also, and this is also the let's call it intermediate research findings. Private actors are not pursuing public interest, full stop. Private actors pursue private interests, or as I call them, interests. Sometimes interests are elevated, promoted to public ones, and then we can look why and how. But private actors pursue interests. At times it might overlap with public ones, but then we should not confuse it. So if private actors are seemingly pursuing public interests, then it's an overlap with the private interest that they are actually pursuing, which has implications for, if you look at it from the regulatory response, since evidence that we actually have on self-regulatory regimes is that they don't work. Timber regulation is one of the very well researched fields of regulation where self-regulation is applied, and we have no evidence that self-regulation actually pursues or achieves, realizes the public interest behind it. But that having said that, in Rotterdam itself, I was teaching a competition law course in a succession of Mark van der Woude, that is quite well known, I believe, in competition policy world. And in that sense, I'm not totally unfamiliar to the topic. I was shadow rapporteur for the DMA, where some of the matters that we discuss here were also discussed. It was my first legislative file, and it was the first time I participated in a trialogue. As an academic, I said trialogues is evilish stuff because it's so intransparent, speaking of transparency. Having participated in one, I have not changed my opinion. But let's say I want to go a step further and we look at this, at the matters that are discussed here on the conflict of interests. Since I believe, and let's allow the politician in me to say this, babies are born innocent, and therefore also academics are born innocent in their opinions. But there are incentives in the world that we are living that makes them change in one way or another. And I believe if we actually want to address the issue of the conflict of interest, we must go a couple of steps further. And that's the way of how it was already mentioned. If I look at research financing, in the Netherlands, we can see what is happening if we have a populist government having the possibilities to change the way of how research finance is funded. Universities are currently struggling. Some go much into restructuring processes because the funding part, the public funding part for the universities is cut down. And that's indeed where we are heading to. But this is also not only just an idea of populism. It builds on a paradigm of neoliberal universities, where the idea is if universities compete with each other, we get better research results. And that is done by reducing the public money part for research and send them all to Horizon grants or ERC grants. Go into competition. The best idea wins. And by that, you get the funding needed for your research. Besides, you finance your work by doing teaching and managerial stuff, which basically means that young researchers are killing each other, are killing themselves by writing every 2 months a new proposal for one of those funding bodies. Having been twice an evaluator for the ERC Advanced Grant, I also know the other side. And it is following a certain kind of logic. If you have a certain CV with a certain kind of already received grants and other things, you will also get this particular kind of grant. New ideas with new methods that are brought in by starters and beginners, they have hardly a chance to be financed. And that makes it, if that's the way of how we deal with public money, but yet we need the financing of it, where do you turn to? Of course, you turn to third money. And at Dutch universities, if you want to have tenure, it's not that there is this discussion on prohibition. Already here, it's worse. If you were the one who got in €1 million third-party funding, you will get your chair within 24 hours. Whilst if you got your 1,000 small grants from the Dutch public research funder, then you get maybe an increase of your salary. So in that sense, the pressure that is on public universities and the paradigm of putting them into competition with each other in order to achieve excellence in research produces all the incentives that pushes academics and researchers into third-party funding and the transformation that comes with it. And the fear subsequent fear to actually make things transparent. The case of Fiona Scott Martin is for me here quite telling. I personally think from her writings as an academic, she's fantastic. I think she would have been an excellent chief economist of DG Comp, especially looking at how big tech markets look like. But she didn't disclose certain research, and that brought her into trouble already in the US, but then later also here. And it is an example then for other researchers, how do I deal with this very problem? Should I dare to be transparent or not transparent? So there is also a problem with having indeed unclarity on those transparency rules. But this is only at the very upper layer of the problem. Down deeper, it's the way of how we finance research, of how we value research, in particular in social sciences. And the very way, if you want to make it as a researcher, you have currently no other alternative than turn to private funding. So this is this part. On the access to data, a lot was said. And indeed, having access to big tech data, speaking of algorithms in the way of how social media platforms are actually working with the data. I remember the discussions we had in the DMA on this particular matter. And there's unfortunately a reason why we don't have such a strict rule in there as we could have had if there was a political majority for that. But this is the core point. I mean, you need to have data if you want to conduct your research. But I also believe going another step further on what we can do. There is also, speaking of obsessions, a certain obsession of making our life complicated in competition law. I call it the more economic approach. That brought the economists into the house. I mean, it's not that competition law needed all those private economists giving advice or putting in evidence or whatever when competition law was created in the 1950s. So we were obviously able, with the way of how competition law was designed for decades, to manage things quite well. And if you look at the amount of concentration on the internal market, actually it seems to have been better than it currently is. So we also got a lot of biased research with all the problems from practice that we have heard by simply having implemented the more economics approach. Why is there a need that something very pretty straightforward, such as the restriction by object, was diluted by economics in order to make it closer to the restriction by effect when we look at cartels? There was a good reason for the distinction between those two categories. Now they got diluted, and we have in both categories economists saying lawyers leave the room quite early, economists enter. And from that moment on, judges and others that are trained in competition law have difficulties to follow, so that they must rely on the system as it works and the credibility of experts that are in the room. And then it works just like with the ERC advanced grants. Those that were gave testimony 100 times have the highest credibility, even though that might not have been actually in the interest of the entire system. So if you change competition law paradigm, returning to a more legal approach, we already would solve a couple of problems if we look at conflict of interest of certain kind of, let's call it, contributors to the discussion. So these are things that are a bit beyond the very conflict of interest manner, but we need to change those elements of the incentives on neoliberal university, research funding, and the way of how we apply competition law and policy in order to address those matters profoundly. Thank you.
I don't know if everyone in the room agrees to the less economic approach and back towards a more legal approach, but that's a whole different conference.
Maybe disclose that I'm a lawyer by training. No. But never practiced privately, always hired by universities.
Thank you. I will now give the floor to Max Bank from Lobby Control. Do you want to reply to any of the points or just go ahead with your own? Free to decide.
I will try to keep it short, but I have to make a few points as well. And I'm looking forward to the debate with the room, but also on the panel. First of all, my disclosure of interests. So I'm working for an NGO which is funded by 80% by private donations. We don't accept corporate money. We don't accept state money. We have two independent foundations on board. So I guess it's also good practice that civil society discloses its funding. I would say we have a large amount of independence in our political judgment. The last 5 years, I've been working on market and lobby power of big tech. So I've been following the DMA debate very closely. And it has brought some light into what has been discussed today. So I've a few insights that maybe help the discussion. How to tackle the conflict of interests problem in both academic research on competition policy and in the policy process itself. I think it's difficult. I agree with Thomas on that, and it's a whole ecosystem that we have to tackle. But I also wanted to bring a positive note into this. We are assembled here with quite a number of interesting people who, in their specific parts of the ecosystem, can contribute to avoiding conflicts of interest, who can also speak to other people about potential conflicts of interest, to ask them for disclosure. You are the ones who are on academic conferences, who are even inviting to academic conference, who can ask on a panel for disclosure. And this makes a huge difference already. And I really can only say, let's use the power that we have in this room to extend this discourse about conflicts of interest in competition policy research and competition policy. That's my first point. My second point, and plenty of the things I wanted to say have been said by Vanessa, which is great. But I just wanted to highlight again the need for transparency and openness in competition policy. I think the FTC experience of the last couple of years has shown what a difference it makes if a competition authority really tries to speak to the public, tries to make clear why it's important to have competition policy in place. Nina Khan and Jonathan Kanter did a tremendous job. And I think DG Competition could do so as well. Thomas can do so as well. Other people in the commission can do so as well. I think especially those people heading these authorities have an extra responsibility to be transparency champions and to be champions of openness, an open competition policy. And I really think we need a cultural change here, and we have a chance to do that right now. We can start right now, and that's also great, right? You talked about the problematic situation we are in a deregulatory phase maybe, but there are things which can be done right now. And I think a cultural change at the top of the Commission, also at the top of national competition authorities, is something we can start with now. Second point is more about the ecosystem competition policy takes place in. And I need to talk about that again. One part, and an important part of the ecosystem of policy making here in Brussels, are think tanks. And think tanks are also doing reports, studies, which are quite relevant to the political discussions here in Brussels. You may know that, of course. And at the same time, these think tanks take a lot of corporate money. And this is oftentimes not disclosed. And we really need enhancement of disclosure for think tanks, both in the transparency register, where there's a lack of transparency, but also, actually, again, I would say competition authorities, MEPs can make a difference. They can ask think tanks to disclose, to say what their interests are. You have a responsibility for the public interest. And I really can only say, please insist on it. So that's my second point on think tanks and on the political landscape. Another one I want to mention, because it really does annoy me, it's about economic consultancies. They were mentioned plenty of times here in this room today. And here I also see a lack of transparency. First of all, many of the economic consultancies here in Brussels are not in the transparency register. They should be. And this is something which can be done by the consultancies themselves. They can decide to do so. They are doing advocacy. They are doing studies, also not only submitting reports on behalf of powerful clients, but they are doing studies, right? And they are organizing panels, whatever. So I think it's high time that economic consultancies join the transparency register. And something else where I see a need for transparency measures, it's about submissions to merger cases. Submission to merger cases are completely intransparent. We don't know what's submitted to the cases, right? I know there are business secrets which cannot be disclosed, but at least a list with authors, titles of the submissions, and even the clients behind it should be something that can be disclosed to the public, so we know who is contributing to the debate of a concrete merger case. So that's the last point on transparency I wanted to make. And a final point on the imbalance of power. There's a huge imbalance of power between public interest groups, civil society, and corporate interests. I think both the Commission and the Parliament need to counterbalance that. And they have actually opportunities to do so. What about installing an advisory group, a civil society advisory group, we could even say a civil society and SME advisory group at DG Competition, where weaker voices in the policy process can be heard and can be heard more often, so we create a level playing field.
Thank you. Very lively proposal. I see the Commission has been mentioned several times. Obviously, Thomas, no pressure, but we know you're not representing the whole Commission here, but perhaps you want to say a few words after this or after other remarks.
My God. No, I think there were quite a lot now. And I have to repeat that I speak in my personal capacity. Let's start with the 2 points that on the more economic approach and on the funding. I must say, I think it's too easy to make this skateboarder see the bit as a straw man. There's undeniably significant progress in our understanding of how markets work, how competition works over the last 30 years. And we cannot switch off that knowledge. That sounds like a kind of it sounds like a prohibition to think or prohibition of knowledge almost. We have that knowledge, so we cannot throw that knowledge into a cupboard and go back to Middle Age because we have learned all of this. Now, on the margins of that, there's obviously lots of space for discussion. We have think that in the US there has always been a structural presumption for horizontal mergers in concentrated market. In Europe, we don't have such a presumption, so you can discuss, should we have one, should we not have one? And that is a very fair and open and good discussion to be had. But to say we go back to how we did things by some of my admired predecessors, I think even they would not like us to go back to that while they were defending this 20, 30 years ago, because we know simply more today. So I think that's not an option, and it's the same on academic funding. I frankly, I disagree that we can have a totally Virgin Mary academia. Doesn't exist in the real world. So we have a messy situation that we have to manage as best as we can. We are stuck with this. I think Toulouse could not have these great researchers at all if there was not some corporate funding. So, and we couldn't make progress in biomedicine, and we couldn't make progress on other areas if there was not also some private funding. Now, how to manage that? Have to internal checks and balances, make sure that you have boards that check this, that you disclose properly. But it's more than just disclosure. It's really, you have to have safeguard mechanisms that kind of help you to overcome that. And young researchers need that help from the top, how to overcome it, because they're very often left alone with this conflict and how to deal with it. But I think we have to, as we in the Commission, with the recruitment of external experts, we have a messy situation that we have to manage as good as we can. Now, on the more radical proposals, the blacklist, I do not see it. I cannot see us as Commission, as a public authority, without rights of defense, without a proper procedure, without a thing to put people on a professional blacklist. We have, there are sanctions now in the sanction regime, and correctly so, Europe has done a lot to make this rule of law compatible. But if we have to start investing the little bit of extra time that we still have into blacklisting people or taking them off of blacklisting, I mean, we are lost. We are already lost. We cannot do the cases. We have 2 people on the phase 2 cases, so we have no resources to blacklist. That's another problem. So I'm a bit skeptical on that. I think that the profession, if it wants to regain the respect, frankly, for me, the profession has a bit lost respect because of shenanigans that have happened and what I've seen in my professional life. The profession has an interest to regain that trust of the public and to auto-regulate, to get, like lawyers, like architects, like engineers, ethical rules into the whole thing, which have some teeth. Because otherwise the profession is also, you see the bit hostility here in this room, sometimes it's also some trouble. So I think that could be a more promising way forward. The SME or Small People's Panel at DG Comp, I think, and that we are not transparent. I would like to know where we are not transparent, because we are perhaps not as adept as going out on everything, but I think we consult, I think we give access, I think we communicate on what we're doing, and we have the Economic and Social Committee, we go to the Parliament, we have again, these resources are taken literally out of the little enforcement resources we have. They're spending, constantly we're spending time on this, where we cannot do then enforcement with these resources to do it. And it's right to do it, but is it really true that as an institution, I don't recognize this as my institution, that we are an intransparent institution? I don't see it. I'm here, we go to conferences, we're very happy to speak with civil society. I've been in meetings with the trade unions and very, very happy to do that.
Can just, but the Article 102 workshop was closed doors.
Yes. Yeah. Okay. On the Article 102, this was another point. Why, Thomas, are you not asking at the beginning of the conference? I think that's a fair point. And I think, as I said, Aviv has published for the Economic Bureau of the FTC new rules, where they say we will in the future always ask them. If we want to do this, I think we have to publish similar rules first. We cannot just start to introduce this overnight. We have to take the time, think about these rules, discuss them with Fernando really carefully in his team. And Fernando will say, "Why are you coming with this? We have cases." But we will have to do this. We will have to publish. So I think we'll watch with interest what the AWIB is doing. We perhaps to our defense, I think what's really the underlying assumption is what I said before. We do not believe that anybody in any of these rooms is not biased. We really believe that strongly, consistently, and this is a point that was made before. And so our trick, if you want, our little trick, is to try to have people from all sides in the room, to have consumers there.
I will now give the floor to Vanessa because we are running over time. Do we have other 5 minutes? Can we? Okay.
I have some questions or comments.
Yeah, I think Vanessa has the right here.
Yeah. So just on that point, I agree you have people in the room, but often I hear the summary of the discussion saying there was a consensus in the room that, or the dominant view was that. But when that dominant view is by people who are paid to be there against the one or two of us who can be there because we can spare the time to do that thing, but our one or two voices against 200 voices on the other side, well, that is not taken into account in the consultations. And I think that would be part of better regulation. And maybe just one other point on this. There is a really important balancing point. A lot of people have made the point about balance. And Tommaso, you made me laugh at the very beginning on the first conference. You were talking about the three categories of academics, those that are just not interested, those that are naive, and then there was the others. And then you said, oh, those that are naive who get paid 10,000 euros for writing an opinion, and everybody laughed. 10,000 euros for an NGO is a lot of money. That is what we're talking about. It's not the millions. 10,000 euros for an NGO is a lot of money. And that is the crux of this imbalance. And from what Renee was saying, this is only going to get worse. So there's a lot to redo, and there is not a perfect world, but I do think it is incumbent on institutions to rebalance, as Max said, as much as possible between those who have the resources and those that don't, that do represent the public interest.
Thank
you. Yeah, go ahead.
Just short answers to your points on transparency. I was talking about transparency and openness, and for me, there's a distinction. The openness was rather referring to what has been happening the last 4 years with the FTC and its communication to the people, right? And I think DG Comp is not doing that. Bundeskartellamt Andreas Mund is not doing that. He could be doing that, and he could change and put more effort into explaining what he's doing and why it's important to tackle corporate monopolies. That's the one thing. And the other thing on and the other thing, I've never had so many bad experiences with freedom of information requests as with DG Comp. I've been working 12 years on transparency in Brussels, and I think DG Comp is far worse than DG Trade, and DG Trade is really bad already.
Can we stop?
Because this, I have to just to put the record. That may well be, but what you haven't mentioned before. This is not a legislative consultation process in which we are involved. We are involved in cases involving private companies with an administrative enforcer. So it's not like we are not talking about access to preparatory documents to regulation or other things. This is really kind of the dirty laundry of the businesses, and they are doing this with the regulator, and the regulator is competent, so that this is not the same transparency as you have for things. Is what's the normal thing of the law is. You don't have access to what is pleaded in court. You don't have access to what is pleaded before a judge, because all of that is full of business secrets and things. So I'm all in favor of publishing what we're doing, but to give these files, the business secrets, we cannot work with them, they cannot work with us if all of that is open. This doesn't work.
Yeah.
I have a request, since we have the luxury of having two great politicians here, Rasmus and René, which is unusual typically. Can you please also do something about the conflict of interest of members of the European Parliament? So at present, and I was surprised, you have an MEP who was until yesterday the policy person of Meta in Brussels, which is the chief lobbyist basically of the Meta group in Europe, which is discussing in the parliament about the DMA and the DSA. Can't you do something to regulate those conflicts, which seem to be very large, in my opinion? It would be great. This person is not of your parties, so there is. But please do something in that respect. It's not just about the consultant. We have a smaller role to play. You have a bigger role to play out there as legislators.
A bombshell just dropped at the end of the panel. What do we do? You want to?
Yes, no, just very briefly, yes, we can do something about it. And I think also like having two MEPs from groups which are actually also like working on this and came up with proposals in the past. Since Qatargate, I think a lot of debates also happened in the parliament. And we also changed the rules for conflict of interests in the parliament, meaning that there needs to be more transparency, declarations and so on. Would you ask me if I think this is enough? I would answer no, that's not enough. And I think also together with NGOs, like some of our colleagues are also like trying to push for more, but there is also now like a current debate on things like this, on how to solve like conflict of interest. And I think that I'm not satisfied with what is going on in the parliament when it comes to this as a Green member of the European Parliament. But compared to other institutions, I would like to defend the European Parliament because you still have a different level of transparency than we are having in many of the other institutions. Not to excuse, but just to explain that I think we have a common challenge there. And like just today in the budget committee, we voted on giving money, putting funding forward for the new ethics body of the EU institutions and the contribution of the parliament. And the EPP, together with the far right, against the S&D, Greens, Liberals, voted it down. The money transfer in the budget committee, which normally is a vote where 90% of us can agree that we are transferring money to projects we agreed on politically before. And that says something about what is actually going on. So no, we cannot be satisfied, and there are huge problems also when it comes to legislation, but there also had been introduced some changes in the past years. That's my first reaction, but yeah, we need to do more.
Thank you. I think we need to wrap it here. Thank you for the passionate discussion.
Maybe René would like to.
René wants to. Okay, one last.
We'll take it and take
We can go on.
Is there now an exchange or not? Is there now still an exchange with the public or not?
Yeah.
Okay, because I was just wondering whether I should just give them the time for the exchange of the public. The reason is I'm still recovering from the very fact I'm also the faculty council chairman at the Erasmus School of Law, which is a medium average school of law, like we have so many, publicly financed. And we were just, I don't know whether I should call it insulted, but I feel humiliated by the very fact that we do publicly financed research with 5,000 euro grants, that this is Virgin Mary research, and that there is a European Commission cutting down funds for FP10. And I hear the way of how it is talked about 90% of young researchers that are forced in writing one research proposal after another, getting rejected one after another because there's only 1 or 2% that actually get accepted and say, yep, go for private money. Otherwise, there's no other. I'm sorry, I'm a bit emotional about the very fact of how my comment of criticizing how research funding currently is organized was done away with a reference to Virgin Mary research. I'm used to a lot in political debates, but this insulting the way of how the research vision should be and how many publicly financed law faculties try to mingle through difficulties. To also think that competition law before the more economic approach was the Middle Ages, I also find a bit difficult. So I also don't continue because otherwise I'm getting really too emotional.
I think it's
that clarifies, because there was on the first point. I really want to be clear. I obviously all in favor of publicly funded research, and I have my whole family in France in the in science and in research, and they are fully supportive of publicly funded research. I'm just saying that in the reality of the limited funds, we have a situation where these conflicts of interest will always arise. This is the only point. And when we have to find a way. So apologies if I was not clear, but this was not my point to attack.
My faculty is struggling over years to not get dependent on private funding, trying to manage high quality research and education simply with public funds, not by getting into this trap. But okay.
Thank you, thank you. No, we can continue after other questions from the audience.
Well, for eventually, no. I can just translate. We have a mic there. So, Walter, maybe say who you are so people know you.
I'm Walter Wills. I work at European Commission. I speak in private capacity, of course. I trained both economists and lawyers. The point of the more economic approach that I agree with what Lilian Bassi said was also brought up in the first panel by Christina Cafara and Ruprecht Pottsman. I don't think that going back from that would be throwing away knowledge which is relevant. Advocate General Colcott, in one of her opinions, has made a comparison with rules for speeding on the road. You could replace the rule which says that you cannot speed more than 50 in a built area by a rule which says you cannot drive at such a speed that it is likely to cause a problem. Or you can even go further and say you cannot drive at a speed where it is established that it has in fact caused a problem. If you would move the law from the simple rule to the complex rule, you would develop lots of knowledge, because lots of experts would need to be deployed to assess in the specific case whether the driving more than 50 caused the problem or not. But do we really lose something from losing that knowledge and losing the experts, which probably there would also end up being biased because the best experts would be the one working for Porsche? I don't think we would.
Another question. Sophie there.
There's a fight.
There were, but at the back there were questions.
Thanks for this very interesting panel. I think most of the conversation revolved around transparency and sanctions, which are clearly ingredients or solutions to conflict of interests. I'd like to share, but I also heard some panelists asking, is there something else beyond disclosures and sanctions? And that's where I'd like to share some academic insights. Full disclosure, I'm not advertising my own work here. I'm talking about behavioral ethics. Behavioral ethics is perhaps the single most useful part of behavioral science for lawyers. And on conflict of interests, in a nutshell, the key insight is that everyone, even when they do something not quite ethical, wants to be able to look at themselves in the mirror and see a good person. So we are really skilled at telling ourselves stories. And taking this insights into organizations and procedures leads to shift the focus to an ex-ante perspective. And one question becomes, what can we do to reduce the narrative space in which people can tell themselves self-serving stories? There's a lot more to it, but there's not a lot of time, so I'll just stop here. I think a lead author, if anyone wants to look out for more, is Yuval Feldman.
Yeah.
There were first at the back, if I have to be fair. Fairness. You had the
Sorry, I have a lot to say, and I'm not going to say 90% of it. I just want to make 3 observations, and purely as observations, which are going to upset some people, but I just want to. So first, I find it a little bit strange that we have a panel talking about the solution to academic bias, and we had, 1.5, taking your half full, academics on the panel. Just an observation, take what you want from it. Second, I did find your comment about economic research and going back somewhat offensive. I found your response even more offensive. To the extent, suppose that the law would be that we are going to say, we're just going to put 1/10 of people that are out for murder or claim to have murdered, or 1/10 or 1%, whatever percentage, we're going to find them guilty because that's kind of on average the rule, and we're going to ignore DNA and other evidence. Okay? Why is that not the right analogy as opposed to the analogy of the street? I mean, that's not relevant. That's not the right analogy. I do find it a bit ironic that to say the complaint we have against academic experts is that they become too much an advocates like lawyers. So the solution is to take them out and just put only lawyers. Okay, again, just as an ironic beyond kind of all the other stuff. And then one final comment, since you mentioned kind of the FTC and the comment that we put out, one of the ways we got around exactly the issues that you brought up is that it's a Bureau of Economics policy and not an official FTC policy. So it ends up that as a Bureau of Economics, I was allowed to say as the Bureau Director, here's what the Bureau of Economics says. If it was the FTC policy, then we have to get the lawyers involved. So I guess the way we got around that was to take the lawyers out of the equation.
There was a question there also. There was a lady last, but
She has left in exhaustion, I think.
Hi, Todd Davis, PhD student at UCL. Thanks for a very interesting and quite spicy at times panel. A kind of epistemological point, I guess. I keep hearing the word solutions, but I mean, fundamentally, I don't think we can have solutions here. The conflict of interest problem that is in the law is fundamental to the law because of its adversarial nature. And as we try and develop solutions to to address that, then because of this fundamental kind of conflict at the heart of it, then you will get new responses to those solutions which circumvent, no? So I think what this whole discussion is about is really about the immune system of competition law and how when these new kind of ways to circumvent the mechanisms that we have to keep the interests, broadly speaking, aligned with the public interest and not the private interests, as Remy was saying, that we are able to continually develop new antibodies. So the question, I guess we don't have time to discuss anymore, but the question would have been, how do we maintain this healthy immune system in antitrust from like the institutional level, in the commission, in the courts, in the kind of argumentation that happens, all the way down to the individual level. Tommaso, for example, was talking about how many economists are not aware of these bias issues. So all the way through the stack, if you like. Thanks.
Well, I think we really need to wrap it up now. It was a wonderful debate, very lively. Thank you all, and have a good evening.